Before we go on the record, I want to make sure that those in the hearing room can hear me. And also, Jacob, the Zoom needs to be toggled so that I can start my video. And Jacob, if you can hear me, I'm trying to do a mic check and also have the producer change it so that I can start my video.
Tommy, can you hear us?
I can. Are you able to hear me now?
Yeah, I can hear you.
Okay, I'm gonna try my video again. That's still not able to turn on.
Okay, bear with us one
Okay.
one.
Yep.
Tommy, we're gonna switch you to an attendee and try and promote you again to a panelist.
Okay, thank you. I am still getting the error that says I cannot start video because the host has stopped it.
Okay. Um, Bear with us one more minute.
You bet.
Okay, Tommy, can you try now?
Let me try. That seems to work.
Yep. Sorry about that.
All right, no problem. Let's go ahead and go on the record. The time is 6:03 p.m. and this is the hearing for Deschutes County file number 247-22245-PS, which is a request by the applicant for the county to sign a land use compatibility statement to be submitted to the Oregon Health Authority. My name is Tommy Brooks, and I am the hearings officer in this matter. Before we turn to the particulars of the hearing, I'm going to turn things over to Mr. Ripper to describe how the participation process works for those in the room and those online.
Just trying to share my screen. There we go. Thank you. Good evening. For the record, my name is Jacob Ripper, and I'm a principal planner with the Deschutes County Planning Division. The item before the hearings officer is a request to grant county signature on an Oregon Health Authority land use compatibility statement to allow psilocybin manufacturing as an agricultural use on the subject property as a use permitted outright, and a psilocybin service center as an accessory use. Today's hearing will proceed as follows. First, staff will explain the hearing format and how to testify at today's hearing, followed by a brief presentation on the application. The county has established time limits for testimony as follows. The applicant will receive 30 minutes, public agencies 10, the general public 3, and 10 minutes for the applicant's rebuttal. The hearings officer can modify or eliminate these time limits. The testimony portion of the hearing will begin with the applicant presenting first, followed by any agencies if present. Next, persons in support will testify, then those in opposition, and finally, anyone that is neutral to the request will testify last. Afterwards, the applicant will then be afforded an opportunity to present rebuttal testimony. And then finally, staff can make any closing comments. This is a hybrid public hearing with both in-person and remote participation. Before starting your testimony, please provide your first and last name, as well as your mailing address. For our in-person participants, if wishing to testify, please add your name to the sign-in sheet if you have not already. I also have one at the table at the front if you need it. I will use this list to call up participants for their testimony. After your name is called, please come up to one of the tables at the front of the room before beginning your testimony. For our remote participants, if you want to testify, you must be logged into Zoom or have called in using Zoom dial-in option. When hearings officer Brooks asks if anyone attending remotely would like to testify, you will need to use the raise hand feature to notify staff. To do this, you need to press the raise hand button on your computer or smart device, or if you called in, dial *9. In addition to oral testimony, if anyone has written testimony to submit, please hand it to me. If you are in person, please submit your written testimony to me after your testimony. If you are participating remotely, you can submit your written testimony by email to me at jacob.ripper@deschutes.org. Hearings officer Brooks and staff are responsible for conducting an orderly hearing. Any testimony or behavior which is inappropriate will be addressed and may result in that member of the public being removed from the hearing. With all that said, are there any objections to the format of the hearing? If you are attending remotely and have an objection, please use the raise hand function. I'm seeing none in the room, and sorry, bear with, and none online. So seeing none, I will turn it over to the hearing over to hearings officer Brooks.
Thank you, Mr. Ripper. And as just described, we are following a hearing process that's set out in the county code, and I will make sure to provide sufficient opportunity for everyone to participate at the appropriate time. This application is being considered through a quasi-judicial process, and I will consider only the factual evidence that is in the record. I will then apply those facts to any relevant provisions of the county's comprehensive plan and land use regulations. The standards and applicable criteria that are relevant to the hearing were identified in the public notice announcing the hearing. They are also set forth in the staff report, and the public notice and staff report are posted on the county's website and available directly from staff upon request. It is important that you direct all of your testimony to the standards and applicable criteria. If you believe a criterion applies that was not listed, you may address the unlisted criterion. However, I urge you to also explain why the criterion must apply and to do so with specificity so that other participants can respond and so that I can address that issue in my decision. And I might go into a little bit more detail later about that. I think this is a pretty unique hearing because it's for a land use compatibility statement, and the criteria that we're looking at are very narrow. So just please keep that in mind before you begin your testimony. The failure to raise an issue with enough detail that enables me or other participants to respond may preclude your ability to appeal that issue to the Land Use Board of Appeals. And the failure to raise a constitutional or other issue relating to any proposed conditions of approval, again with enough detail that allows me to respond to that issue in my decision, precludes an action for damages in circuit court. I do serve as the county's hearings officer, and in that role, my job is to be a neutral decision maker. So while I have a contract with the county to serve in this role, I am obligated to remain impartial, and I do not represent the county's interests or the interests of any other participant. To that end, I'll state for the record that I do not have any ex parte contacts to disclose. I do not have any relationship with the applicant or to any other participants in this proceeding that would prevent me from remaining impartial. I have communicated with staff briefly, but only to discuss the particulars of today's hearing and not the substance of the application. So at this point, Mr. Ripper, can we determine how many people have signed up to testify?
Yes, so far in person, I have 5 in support, 9 in opposition, and we have 6 people online. If anyone would like to testify in support, can you use the raise hand function? So that's an additional 2. And if you can lower your hands, please. And then anyone online wanting to testify in opposition, please raise your hand. So yeah, that's brought us up to 7 for support and 9 opposed.
All right, so I do, and I've read a lot of the comments that have already been submitted to the record, and so I do want to reiterate, especially in light of the number of people we have here, and I don't want to, hopefully I'm not getting ahead of the staff presentation too much, but what we're dealing with tonight is not really your typical land use hearing where we have an applicant with a proposal for development that's being either approved or disapproved. And the matter before us tonight is a land use compatibility statement, or a LUX. And the LUX is a document that the county signs and is submitted to a state agency as part of the state agency's permitting process. And the reason I reiterate that is because there's really a very narrow question before the hearings officer, which is whether or not the applicant for the state permit, whether they already have land use approval for the use or they can get land use approval for the use and to fill out this form. So this is not a forum to express support in general for psilocybin uses or manufacturing or service centers. It's not a venue to express opposition to that kind of use. Basically, the decision to allow the use in the zone has either already been made or it hasn't been made. And I would really encourage everyone to limit their testimony to the question that's before me. And if we get into a lot of back and forth about the pros and cons of psilocybin uses, that we're going to be kind of far afield from the task that's at hand. So please keep that in mind. And with that caveat, I'm going to turn it over to staff to present the staff report.
Thank you. So yeah, I just have a brief staff report, like I mentioned before, just to go over some basics of the application. It's the subject property is shown in the image outlined in red. It's 21230 Yeoman Road. It's in the to the northeast of the city of Bend. It's adjacent to the city's urban growth boundary, which is the blue hatching that you can see in the bottom half of that image. And it's approximately 4.36 acres in size. Zoning of the property is suburban low density residential, or SR 2.5. That's that kind of gray overlay color that you see. And then to the east is the orange color is exclusive farm use, or EFU. And then everything else left in this image, the green and the blue, those are properties within the city of Bend's land use jurisdiction. So the county does not have jurisdiction there. Again, the proposal is for county signature on an Oregon Health Authority land use compatibility statement, or LUX, specifically recognizing psilocybin manufacturing as an agricultural use allowed outright in the zone, together with a psilocybin service center to be allowed as an accessory use to that agricultural use. Some of the topics from the staff report to address that I just wanted to quickly point out. Probably the most important is the goalpost rule, which is a state statute that that basically says when an application is submitted, the standards and criteria that apply that day are to be used for the review of that application. In other words, if the rules change after the application is made, those new rules do not apply to that application. Another brief point was if non-conforming use criteria applies, and if it does, how so? And then if this is an approval, what conditions of approval should be imposed and are appropriate? The staff report suggested, for example, requiring site plan review, because this would be a commercial use, and site plan review reviews site design for things like parking and circulation, access, landscaping, site layout, those and similar features. All of the record materials are published at the following website. And I did want to mention that since the staff report was published, this says 4 additional public comments were received. I actually received a 5th right before we opened the hearing. The other 4 have been uploaded, and then I also received additional comments from the applicant. Those have been uploaded and are available online as well. With that, I said I would keep it brief, but I am available for any questions from the hearings officer if you have any at this time.
All right. Mr. River, I do have some questions, and I'm going to put you on the spot a little bit. And it mainly has to do with what, I guess, really the application of the goalpost rule and how that's presented both by the applicant and by staff. At least coming into this proceeding, and I am open to a lot of argument about this, I'm not convinced that the goalpost rule does apply because ORS 215-427 applies to certain county decisions like a permit, limited land use decision, or zone change. And my understanding of how a LUX is processed is that LUBA does not consider that to be a permit in the sense that, for example, the site review plan would be. So I don't know if staff has had a chance to dive into that and has an opinion on it, or would like to answer that question later. But I thought it only fair to let you know that I'm struggling with that on the front end to really understand what issue is before me and what I need to decide at the end of this hearing.
Sure. Yeah, absolutely. I can address that now. On page 6 of the staff report, under Title 22 of the Deschutes County Code, it's section 22-16-010, review of development action applications. So development actions are essentially ministerial reviews. Under subsection B, it says the planning director has the discretion to determine that for the purposes of Title 22, a development action application should be treated as if it were a land use action application, land use application being discretionary. And in this case, that's what the planning director decided to do, because we did determine that there seemed to be some discretion being exercised here. So we've applied land use action procedures to this application.
Okay, thank you. And I noticed that in the staff report and have given that some thought. Again, my thinking is that this applies the procedures of the land use action to a development action procedure. And I'll raise this issue with the applicant as well. The thing that's informing my thinking right now is a decision from 2014, and it's called Curl v. Deschutes County, that addressed how the county processes a Lux, and that even if there is some discretion involved, that it's basically like a zoning determination that doesn't actually review the development itself. So again, I wanted everyone to know what I've reviewed going into this hearing and sort of just have the benefit of my thinking. And again, I'm open to arguments for why this is a permit under ORS 215-427, why the goalpost rule would apply. But if it doesn't, I think that dramatically changes sort of the request of the applicant. So thank you for answering that question.
Sure. Yeah. Thanks, Hearings Officer Brooks. If there is an open record period, I'd be happy to drop in some other decisions in Deschutes County with similar procedures, so you can see that.
Okay, thank you. So let's move on to the applicant's presentation.
Thank you, Hearings Officer Brooks. My name is Alex Berger with Emerge Law Group, representing the property owners and the applicant. Our address is 108 Northwest 9th Avenue, Suite 300, Portland, Oregon, 97209. Nick Jones, the farm manager for the proposed mushroom farm operation, and applicant Piper Lucas, co-owner of the proposed mushroom farm operation and service center, are here as well and will also be presenting. So this application regards the property addressed at 21230 Yeoman Road, as Mr. Ripper indicated, which is located in the suburban low-density zone, the SR 2.5 zone. The application, as you mentioned, Hearings Officer Brooks, is for a land use compatibility statement indicating that an OHA licensed psilocybin product manufacturer or psilocybin mushroom farm and psilocybin service center are not prohibited at the proposed property. The applicant requests that the county confirm that as of April 3rd, 2023, when the Lux application was first submitted, a combined psilocybin manufacturer and functional or edible non-psilocybin mushroom farm, which I will collectively refer to as the mushroom farm operations, is an outright permitted use. And that the requested service center is also an outright permitted use in the SR 2.5 zone. So, according to the staff report, and it is the applicant's position that the goalpost rule does apply, and the effective date the application was submitted, April 3rd, 2023, is the standards and criteria that should be considered when evaluating this application. The hearings officer has questioned that, and so we may take an extended record period to respond, especially given the case that you cited there. But given the fact that the land use compatibility statement was submitted on April 3rd of 2023, I think it is reasonable to assume that the standards and criteria that applied for the approval of the Lux should be applied in this case to ultimately approve the Lux. So according to the documents in the record, the application was deemed complete on September 29th, 2023, 79 days, excuse me, after the submittal date. So the Deschutes County Code that was in effect on April 3rd, 2023 applies, we contend. So this is important because the Board of County Commissioners did not adopt Deschutes County Code provisions covering OHA licensed psilocybin businesses, including restricting them to certain zones, until April 4th, 2023. So we contend that those provisions are inapplicable to our application. So the only applicable provisions are the DCC governing permitted uses in the SR 2.5 zone in effect on April 3rd, 2023, which are found in DCC 1920-020. The proposed mushroom farm operation and service center are outright permitted uses in the SR 2.5 zone. Regarding the mushroom farm, the DCC lists agriculture, excluding the keeping of livestock, as an outright permitted use in the SR 2.5 zone. The DCC defines agricultural use to include any use of land, whether for profit or not, related to raising, harvesting, and selling crops. State law states that psilocybin producing fungi is a crop for the purposes of Oregon land use law. That is in ORS 475A.570, subsection 1A. The proposed OHA licensed psilocybin product manufacturer would engage in the raising, harvesting, and selling of psilocybin producing fungi. The proposed functional mushroom farm portion of the farm operation also qualifies as agriculture because, as Lubo opined in Horacek v. Yamhill County, a commercial functional mushroom farm constitutes the raising, harvesting, and selling of a crop. The proposed mushroom farm operation, therefore, is indeed an outright permitted agriculture use in the SR 2.5 zone. Regarding the psilocybin service center, the Deschutes County Code lists as an outright permitted use other accessory uses and accessory buildings and structures customarily appurtenant to a permitted use subject to DCC 1992-020, and that is found in DCC 19-20020B. An accessory use is an incidental, appropriate, and subordinate, apologies. An accessory use is a use that is incidental, appropriate, and subordinate to the main use on the same lot, which is found in DCC 19-04040. The proposed service center is indeed incidental, appropriate, and subordinate to the outright permitted mushroom farm operation, or put another way, the mushroom farm operation predominates over the service center. Case law prescribes 3 factors in determining whether a use is accessory to the predominating use. Those factors are the nature, intensity, and economic value of the relative uses, and no one factor is dispositive. Regarding the nature of the relative uses, the service center supports and promotes the mushroom farm operation by providing an outlet for the psilocybin manufacturer. Under Oregon law, service centers are the only outlet for psilocybin products, so the 2 uses are indelibly linked. The service center will also provide educational and retail services for functional mushrooms as well. These services include sales and tastings of the functional mushrooms themselves and teas from mushrooms grown on site. The nature of these uses would have a minimal impact on the surrounding properties. The subject lot is nearly 4.5 acres in size, and the proposed uses would be adjacent to neighboring yards and a fair distance from neighboring structures and homes to the north, east, and west of the site. The area immediately to the south, across Yeoman Road, as Mr. Ripper mentioned, is in the City of Bend's urban growth boundary and is zoned urbanizable area. And that area is largely occupied by a large recreational and commercial sport venue complex, which in terms of noise, activity, and intensity has a much greater impact on the surrounding area than the proposed uses. So ultimately, the proposed uses would have very little impact on the surrounding areas. In terms of the second factor, intensity, The proposed service center will only occupy 36% of the area that would be occupied by the mushroom farm. The hours of operation for the service center would also be greatly limited when compared to the mushroom farm. The service center would operate at a maximum of 39% of the time that the mushroom farm operates. The service center would also have far fewer employees on site than the mushroom farm. The current anticipated ratio of mushroom farm operation employees to service center employees is 3-to-1. In terms of economic value, the projected revenue for the service center would be 29% as much as the mushroom farm operation. So applying these factors, the relative uses, that indicates that the service center would indeed be accessory to the mushroom farm operation. The service center is also customarily appurtenant to the mushroom farm operation. The Oregon legislature anticipated co-location of a service center and manufacturer as indicated by the Oregon Psilocybin Services Act, which specifically states that, and I quote, "The operation of a psilocybin service center may be carried on in conjunction with the psilocybin producing fungi crop." That's in ORS 475A.570 subsection 3. And although we contend it's not applicable here, the current Deschutes County Code governing psilocybin service centers also specifies that, and I quote, "The operation of a psilocybin service center may be carried on in conjunction with a psilocybin producing fungi crop in the EFU zone." So the County Board of Commissioners also acknowledges the complementary relationship between a manufacturer and a service center. From a practical standpoint, the service center would be comparable to other widely accepted accessory uses in Oregon, such as an on-site farm stand that sells apples at an orchard, a tasting room at a vineyard, or a tap room at a brewery. The law and common sense presume that a service center is customarily pertinent to a psilocybin product manufacturer. We wanted to briefly address a couple of the other issues that were in the public comments in the record. First, regarding school proximity, state law prohibits the location of a service center within 1,000 feet of a public or qualifying private school. We've ascertained that the nearest school to the proposed site is the Ponderosa Elementary School, and that school is well over 1,000 feet away from the proposed site. So the school buffer regulation does not prohibit the service center use. Other public comments indicated that a psilocybin service center is not suited for the family-friendly character of the neighborhood. And although we appreciate those comments and the applicant will strive to limit the impact of the proposed uses on its neighbors, those comments do not invoke the standards and criteria that we contend are applicable to the application and do not have any bearing on whether the proposed mushroom farm operation and service center are outright permitted uses in the SR 2.5 zone. And so to conclude, because agriculture is an outright permitted use in the SR 2.5 zone and the proposed mushroom farm operation constitutes agriculture, we ask that the hearings officer approve the issuance of the land use compatibility statement for the proposed psilocybin manufacturer use. And because the proposed service center is an accessory use customarily appurtenant to the proposed manufacturer, we respectfully request that the hearings officer also approve the issuance of the land use compatibility statement for the proposed service center. I would now like to introduce the farm manager of the proposed mushroom farm operation, Nick Jones, who would like to make a few comments. Is Nick available?
Can we sit here?
Yep, you can sit there.
This good to go? Hi, everybody. I'm Nick Jones. I'm a local entrepreneur and have lived in Central Oregon my entire life, been for the last 12 years. I raised my family here, actually not too far from this property. I have been a mycologist for the last 6 years. I have in my entrepreneurial ventures, I got into functional mushroom product development. And in that, I had a mushroom farm that I worked with and spent a lot of time at. The largest gourmet mushroom producer in Central Oregon, who sells all of the mushrooms to the grocery stores and to the restaurants. I worked very closely with him and other mushroom producers all over the Northwest to source the highest quality of functional mushrooms to develop products with. Then I used those products. We did research studies with the head of biology at OSU Cascades, Christina Smith, to understand the highest and best use of functional mushrooms for different individuals. And so that's kind of where I come from in this whole journey with this team is I know mushrooms and mushroom production and understand functional mushroom production. Psilocybin is just another species of mushroom. So all of the same growing standards and methods apply for just the same species. So one thing that I really want to touch on that I'm hearing a lot is we had in Deschutes County, marijuana was legalized and the production of marijuana was legalized. And I really want to separate drastically psilocybin and marijuana. There's no comparison in the growing processes of any kind. And mushrooms produce no smell. They produce the process of growing mushrooms requires no systems greater than a residential home. It is all standard HVAC. In our case, we'll likely have mini split systems, which will be even smaller and quieter than a traditional larger system for, a 3,000 or 4,000 square foot home that might have multiple units, HVAC units outside producing sound. We will have a even lighter footprint than that significantly. We consume very little water in the process. And again, I want to emphasize there is no smell or sound that comes from our process. So it is quieter than a farm running a tractor next door. It's quieter than folks that have horses next door or cattle next door or goats next door. You will very much not know that we are there. So it is it's a very light impact to any of the neighbors.
Want to talk about composting?
Oh, yes. We will be composting all of our materials outside of the farm in an area that is designated within the fenced region of the psilocybin portion of the farm. And we will be using the static aerated pile method. That is what we intend to use. And we will be monitoring the pathogens in accordance with the law, every single day. And we will make sure that, there is zero pathogen production occurring on our end.
Thanks. I'm just going to keep leading you.
Yeah, no worries.
How many employees do you see having?
Oh, I see us definitely needing a minimum of 5 employees to run the farm with its highest efficiency. There will be obviously a psilocybin portion to the farm. There will be a functional portion to the farm, and then there will be a portion that we are having dedicated to the product production for all of the functional mushroom products that people would consume in like the form of capsules or powders that they might purchase. So those products, functional mushroom products, can be shipped online all over the world. And so we intend to, have functional mushroom products available. And for psilocybin products, we will be able to distribute those to other qualified facilities around the state.
And shipping, if you're a manufacturer. Yeah,
Oh.
sure. This is a little awkward because we're doing it together here, but shipping or sending the psilocybin mushroom to another service center, is there a benefit to having the service center next to your farm?
Yeah, actually, so the Multidisciplinary Association of Psychedelic Studies, which is really the foremost leading research organization in the country, says the three most important things for successful experience for a patient is that they have a good mindset going in, that the setting is good for them, and that it is safe as well. So setting, and safety are the three S's they call it. And in this case, we believe that patients will really have a really nice time being able to find the mindset, the safety, and the setting here, knowing that transparently the product that they're going to consume for their session will be produced on site in a eco-friendly way, that, you know, they can see the process.
Mhm. Awesome. I'll introduce myself. I'm Piper Lucas, the applicant, and I'm representing the service center portion of this. And my passion is really from 15 years of understanding psychedelics, how they're used in the indigenous cultures in South and Central America, and how it's used for healing is in nature, and that has been proven to be best and safest. So coming into Oregon and seeing what's happening here, I wanted to provide a service center in a legal area that would provide healing for my community. Providing medicine on site is really important to what we're trying to do, because having the medicine there means you don't have to ship it away. It's close by in proximity. I think that's important for people as they journey there. Therefore, the farm and the service center use are connected. There would not be a service center if we didn't grow mushrooms. The functional mushrooms are also important for the uptake of psilocybin, so I don't want to forget or minimize the importance of the functional mushrooms we'll be growing as well. The intensity of the use it's not what a lot of people think it is. We want quiet. We need quiet. People want to have a private, natural experience where they can hear the birds. So the goal is not to increase any noise, any traffic, any dust in the neighborhood whatsoever. People are going to come and they're going to drive. There was a comment from Mr. Christensen, I believe, about transportation. There is a law requiring a transportation plan, and I appreciated the question. So people won't be walking or driving in and out. They come and they are served after a preparation session where they are deemed appropriate to take medicine, and they sit with a facilitator. The facilitator is trained by a school and has 160 hours of training. And in the session, which lasts anywhere from 5 to 8 hours, the person will have their experience, and it's mostly blindfolded and quiet. They're in an internal situation. There might be light music, but very, very light, and usually in earphones. So the noise and impact to the neighbors would be minimal. We also considered this with the siting of the service center, in that it's in the back of the lot. So it's farther away from the street. I want everyone to know that I am careful when I design structures. I designed the Hanai Community Center, and it took 7 years. And I am grateful for those clients. And I want to be mindful of my neighbors, the neighbors on this site. I don't want to be a nuisance. I don't want people that come here that are relieving their traumas and their whatever they're working on to feel like they're not welcome. And it's not that people need to welcome them here, but I just want you all to know that I hear your comments. And I want them to be addressed, honestly. It's a great privilege to have psilocybin become legal here, as we have first responders, veterans, people who are desperately seeking this treatment, and they come to Oregon. And from my experience, knowing what is best, being served in a downtown Portland clinic with sirens going by is not serving people best. I appreciate all of the comments here and the concern. Thank you.
Thank you, Piper. The applicant just wishes to say another couple words about the goalpost rule and just reiterate Mr. Ripper's comment in the staff report regarding DCC 2216010, which states that a development application may be handled administratively by the planning director, but also that the planning director has the discretion to determine that for the purposes of DCC Title 22, a development action application should be treated as if it were a land use action application, which we would contend effectively transforms the application into one in which the goalpost rule would apply. Otherwise, I would just reemphasize our request that the hearings officer grant the land use compatibility statement application as applied. Thank you.
One question for you, Mr. Berger. Do you, what is your, I guess, either agreement or disagreement with the part of the staff report that says other approvals may be necessary, like a site plan review?
We do not argue that a site plan review may be required or not required. We're prepared to go through the site review process.
Do you think that a site plan review is not required?
Well, it is an outright permitted use. So typically they are not required. So I guess it would be our position that it is not required, no.
All right. And thanks for addressing the goalpost rule again. I hear what you're saying about the applicability of the county code and how the county code converts at the planning director's discretion a development action into be treated as if it were a land use application. I think what would be helpful for me in my decision, and not just from you, but from staff and any other participant, is to understand if that is if that has the effect of imputing the process for approval versus the substance, and whether or not the county can, through its own code, modify what the state statute says about the goalpost rule. I said it earlier, but I'll, again, for the sake of everyone, the one case that I'm aware of that involved Deschutes County is called Curl v. Deschutes County. It's from 2014, and the citation is 69 Oregon Luba 186. If that is not good law anymore, it would be good to know. If it is good law, but you can distinguish that law, that would be good to know. If there are other cases that the county has had where it has applied the goalpost rule to a Lux, that would be good to know. And in short, anything that's other than the process of a land use application, but I'm talking more about the substance. So I'll leave it up to you to request the record be open, but just from my standpoint today, those are the kinds of questions I'm going to need answered if I'm going to kind of, I guess, change where I am at the moment.
Understood. Thank
Right.
you.
Thanks. Anything else from the applicant?
Actually, I was just looking at my notes. A few things that might be applicable and helpful is that there are a half acre of water rights from COID that would directly go to the mushroom farm. So again, reinforcing the farm use as an outright permitted use. Also, just addressing the number of employees in the service center, we would have 2. And we're hoping to operate 4 to 5 days a week. General operating hours would be probably 10 a.m. to 6 p.m. for a general journey. 1 or 2 days a week may open a little bit earlier. 1 or 2 days a week may go a little bit later, but generally that's our idea. There was also a comment about a bus stop, and that is definitely my mistake. When I was driving up Yeoman, it looked like a bus stop to me. Since then, I have talked to Scott Aycock, who is, I want to say he's chairman, or he's part of the Central Oregon Intergovernmental Council, and I've asked about adding a bus stop. Because there are all of those extra apartments going up, they are considering that. So I just wanted to address that was my mistake, and I am correcting it. There was also another question in the comments about who all is going to work there, who is serving, and that's a great question that we're going to have someone speak to later. But everyone needs a worker permit that's going to be on site handling psilocybin. And I think that's it for now, answering questions.
Okay, thank you. The applicant will, of course, be able to come up on rebuttal at the end of all the public testimony.
Thank you.
Thank you.
Thank you.
So we're going to turn to the, I guess, are there any agencies that have signed up, Mr. Ripper? And didn't
There's
sound like over.
No.
Okay, then we will move to the portion of the testimony where we will take testimony in support of the application. I'm going to give this reminder probably at each step. But again, I think the questions before me are whether or not this is an agricultural use and whether or not the service center is ancillary to the agricultural use, and whether or not any of that is relevant if basically if the goalpost rule apply or not. I know there's going to be a large inclination for people to support sort of the underlying purpose of the use, and I just, again, you can use your time for that. I initially think it's not going to be relevant. So if you could really help me focus on the criteria that I'm addressing, I would appreciate it. Thank you.
All right, we'll start with folks that are in the room. The first person I have signed up in support is Brad Piper.
Hello, my name is Brad Piper. I'm a retired firefighter of 25 years and a father of 3 children. I suffered a traumatic childhood, and over the 2 decades in the fire service, I had repetitive trauma. At an early age, I learned to cope with stress, depression, and conflicts, and discomfort and unhealthy habits eventually caught up with me. I tried all of major Western medicine models to try to break these habits, but they never lasted. 5 years ago, I finally crossed paths with psilocybin in a therapeutic setting. And after one session, it completely obliterated my old way of thinking. It was the first time as an adult that I saw what my destructive habits were doing to my health and my relationships. I was finally able to take ownership of my poor behaviors and actions. My healing had begun. Each time I've used this medicine, I've become more present and a loving father and more compassionate, empathetic human. Psilocybin works. It's effective, powerful, and real. I believe so much in its healing power, I enrolled in a facilitator program, which I graduated from 2 weeks ago. And through all my training and research I've done in psilocybin over the years, the one most common theme has been seen is the powerful and direct connection of nature with psilocybin during this process. Each facilitator I've spoken to recommends their clients spend time in nature before and after their sessions. The majority of rooms where these sessions occur are painted with natural tones, pictures of nature scenes, and houseplants throughout. Many of these soundtracks that are used during these sessions incorporate nature sounds. We're just trying to copy nature in this indoor setting. And there is a reason. This is how the indigenous people have been doing it for thousands of years and continue to do it to this way today. The medicine is grown, harvested, and dried and consumed. The mental and emotional state of our country is struggling. Western medicine is failing. I'm grateful Oregon is brave enough to be the first to explore and support healing power of psilocybin, but we can do better. It's fair to say the entire psilocybin facilitation industry places an enormous emphasis on the positive impact nature has with the healing process. So why wouldn't we just make it possible for people to heal surrounded with or immersed in a true natural setting during their psilocybin session? These sessions can be profound, powerful, and life-changing. Most people are seeking peace, calmness, connection, and clarity in their lives. Stepping outside to a quiet, serene, natural setting after this experience is much more impactful than entering a busy, congested, crowded city environment as our current model provides. I have experienced several psilocybin sessions and can without a doubt say the ones that occurred in nature had the most powerful and profound effects. Most everyone listening right now has been positively touched by nature at some point in their life, whether it was staring at waves at a crashing beach, watching a river flow through the forest, gazing at stars on a clear night, or witnessing a glowing sunrise or sunset. That calm feeling we get from these experiences, the healing power of nature. Psilocybin simply magnifies this feeling. Please support allowing psilocybin facilitation to take place where it originally was intended, directly in the palms of Mother Nature. Thank you for your time and consideration.
All right, next I have Ryan Reese.
Hey there, I'm Ryan Reese. I'm a tenured associate professor of counseling at Oregon State University here at the Cascades campus. I'm also a licensed professional counselor in private practice, and I serve people presenting with complex PTSD, depression, and anxiety. I'm also the founder of Quest Therapeutics, which is a psilocybin facilitation company here in Bend. I'm here in support of this land use proposal. I'm approaching 15 years as a researcher and expert in eco-wellness counseling, a field dedicated to investigating and engaging in best practices relative to addressing the human-nature connection in therapeutic settings. Over the past 2 decades, over 1,000 studies have demonstrated the positive effects that the human-nature connection has on people's health and wellness. For instance, having views of nature reduces psychophysiological stress within research participants. Nature immersion contributes positively to attention restoration and seems to disrupt a network of brain regions responsible for maladaptive thinking patterns that underlie depression. In addition, numerous studies have demonstrated the positive effects that nature exposure has on mitigating PTSD symptomology. Moreover, a growing body of research suggests that the setting wherein psychedelic experiences occur are critical to maintaining safety, both during the experience and maintaining psychological stability within participants post-dosing. This is in addition to the growing body of research clearly indicating the safety and efficacy of psilocybin in treating mental health challenges such as treatment-resistant depression, end-of-life anxiety, and substance use disorder. Specifically, in my experience thus far as a practicing licensed psilocybin facilitator within the Oregon framework, I can attest to the importance of clients having contact with nature during their psilocybin journey. Thus far, I've noticed clients feeling confined and claustrophobic without being able to view or access the natural world, which potentially contributes to stress responses that counter psilocybin's potentially transformative properties. To date, our region lacks a service center having a view of a tree, let alone any kind of opportunity for clients to experience the outdoors in a safe and contained manner. The proposed use of this space could be a critical next step for the Oregon framework, and also in finding ways to collaborate with researchers such as myself on exploring the potential importance for nature exposure before, during, and following psilocybin administration. Lastly, I briefly just want to speak to the safety concerns. Of the psychedelics, research suggests that psilocybin has one of the safest drug profiles that there is. Additionally, legalized drugs such as alcohol, which permeates our culture here in Bend in Central Oregon, pose much greater risk to our community's children and their families than does psilocybin. I invite us as individuals and as a community to continue educating ourselves and one another about the realistic outcomes of psilocybin facilitation services. The proposed uses of this land would be operating under the strict guidelines of the Oregon Health Authority, and all clients, licensed facilitators, or manufacturers must adhere with any of these rules, thus ensuring the safety of our community. Thank you.
Thank you.
All right. Next up is Josh Gage. Oh, yes. Yeah. If everyone can say their name and mailing address, that would be lovely. Thanks.
Thought those were online.
For in person and online, please. Yep. No, that's fine. I have it on the sheet. Yep.
We just go with it, or do you have a signal like ready, set, go?
Just go with it.
All right, awesome. Thank you guys for the opportunity to speak to this. My name is Joshua Gage. I am a true local. I was born in St. Charles, went to Juniper Elementary, graduated from Mountain View. Faced houselessness here before I joined the military in 2003, where I served in Iraq, 2005 through 2007, and deployed to various countries in Africa. Then I worked as a first responder, Deschutes County Parole and Probation. And before facing my own mental health challenges and barriers and having to restart, where I went back to grad school and now work as a crisis clinician. And I'm here today, separate from my duties of my primary position, where I work for Deschutes County Behavioral Health as a crisis clinician at the Stabilization Center and for the Mobile Crisis Assessment Center, now known as the CCRT, Community Crisis Response Team, where we respond to acute mental health crisis. And I'm headed there after this, and it's something that I'm very passionate about. And I look at a facility like this as another tool to treat various populations across every socioeconomic landscape, across every race, across every creed, because all people are suffering from trauma at various levels. According to VA.gov and the Veterans of America, Oregon has 212,000 to 265,000 veterans here. And many of them are searching for just another tool in order to increase their quality of life, will also feel connection to that around them and to those around them. Anything that we can offer them to help improve their quality of life and the reduction of symptomology that we see, including suicidality, mania, schizophrenia, everything under the sun, we need to offer my brothers and sisters, not only in the armed forces, but first responders, but everybody, from somebody who's facing homelessness out in dirt world to people up in Northwest Crossing. People are looking for hope. And in Oregon, we have an opportunity to provide that in this lawful facility and lawful land use that's proposed today. In Oregon, according to Mental Health America, in 2002, we were 49th in the nation for adults in mental health, 45th for youth, and 46th overall. While this isn't a cure-all and not some miracle pill, it's something that can help people. In 60% are reporting reduction of symptomology. And that is huge when you look at all pharmaceutical prescriptions that are given that have side effects such as weight gain, loss of sexual functioning, everything. We need to give people the opportunity to feel connection to their bodies and to that around them. And with this land use, it's beautiful. It's beautiful. I don't know why. I mean, reduction of water use across the board. This is a proper land use facility. Thank you for your time. I wish you all the best.
Thank you.
Next, I have Allison. I'm sorry, I can't read the last name. Yeah, thanks. Yeah.
Good evening. My name is Allison Hohengarten. My address is 61839 Dobbin Road here in Bend, Oregon. I'm also out in a little part of rural Central Oregon, and I'm a local attorney. I appeared in front of you, Mr. Brooks, a couple of times before, and I'm here in support of this land use application, and to try to narrow it down. I'll try to stick with the land use arguments as best I can. I would just also echo what Mr. Berger said very eloquently about this application and this use being a crop under Oregon law that's been approved by the voters, and the ancillary use is also the service center, I believe, is also an outright permitted use in this zone. So having read the staff report and some of the other things associated with this application, I certainly think that the applicant can get land use approval and or should get land use approval, and therefore I'd ask that you sign the land use compatibility statement. I also know Piper, have known her for many years, and she's a very conscientious person and an incredible architect as well. And so if there were a site plan, which I understand staff has recommended, if you approve this, I know that it would lay things out and in a lovely way that also might put other people who are in opposition to this at ease. And I also just want to emphasize that we should go back to the law here. We are talking about what Oregon has identified as a crop. A crop is a crop is a crop. A horse is a pig. All the agricultural uses that we've allowed are all different, and this is a brand new one. And so it brings up some questions and curiosities, but I think it fits within the definition of what's allowed. Not only what's allowed, but what is an outright use. And I just also emphasize that what you've heard from some people today, even though it may not be on the land use side, this is the kind of crop and the kind of two uses that must go together. And so doing them in the same spot makes good sense to me, for safety reasons, for a number of reasons that are the nature of this crop and what is being done for it therapeutically and medicinally. Yeah, I think the incidental, appropriate, and subordinate arguments Mr. Berger made very well. These two go together, and we're not just talking about psilocybin mushrooms. We're talking about functional mushrooms as well, which is another crop. And I think it's been laid out pretty well there. And I'd ask you that you approve the compatibility statement. Thank you.
Next up is Beth Davies. So that was a decline to testify. Next, I have Hallie Jones.
Hi, my name is Haley Jones. I'm a resident of Bend and I've grown up in Central Oregon my whole life. I just wanted to speak mostly to, I have been a mycologist for a couple of years and I worked at Deschutes Gourmet Mushroom Farm. And I just wanted to let the community know more about what the composting pile and the farm look like. They are in just one building. There's no sound coming from the outside or smell. And I have never seen the farm be a disruption to anybody in the neighborhood. And so just from my own experience of what I've seen firsthand, of a farm operating in a neighborhood, growing fungi and not disrupting anything in the neighborhood or really functioning any different than any other farm. And that farm is on a 2-acre parcel. So that's all I have to contribute.
Thank you.
So that concludes everyone in person in support as far as I have. Yeah, I'm not seeing anyone else raise their hand. So we'll move to online participants. Again, if you would like to testify, use the raise hand feature if you called in *9. And first up, we'll go with Benjamin.
Hi, yes. Can you all hear me okay?
Yes, thank
Yes,
you.
we can. And just as a reminder to everyone, please state your first and last name and mailing address.
I will. My name is Benjamin Brubaker. My mailing address is 1110 West 27th Avenue, Eugene, Oregon. I come as somebody who's involved heavily in the training side with folks that are becoming licensed facilitators. My background is over 20 years in the mental behavioral health field. Majority of that here in Eugene, Oregon with Whitebird Clinic as a crisis worker, both on our phone lines at Whitebird Clinic as well as the mobile crisis intervention van Cahoots. I've also spent most of that time training and becoming one of the coordinators for the Rock Medicine program that provides psychedelic harm reduction medical care out at festivals and events across the state. So that's kind of some of my background, and I am coming just to help kind of like make sure that folks understand that training facilitators takes months of classes to become certified with a very high focus on screening and preparation to ensure safe and effective psilocybin sessions. Folks that we want to become facilitators are also trained on key intervention strategies that can ensure that the individual receiving services remains calm and grounded throughout the session. Individuals that want to become facilitators are trained in history, pharmacology, core facilitation, integration, and other modules to ensure that they'll create a safe and grounded container for those that they serve. I want to note that medical and behavioral health professionals, many of whom are currently or in the past have taken our class, are involved currently as both facilitators and as advisors, really making sure that folks are providing wraparound care for those seeking services with additional trainings to integrate psilocybin services into the existing mental health and wellness continuum of care. So this just isn't something that's just separate. Again, as one of the other speakers noted, this is really just another tool in the toolbox of the social safety net. These services are also bringing people to Oregon from across the country, with most service centers reporting that a majority of their clients are from out of state. And many service centers are reporting that they are trying to focus on providing services, especially to Oregon residents that are low cost, no cost. There's a high amount of focus within the Oregon service center environment on equity and inclusion and making sure that we're getting these services to those folks in our own communities that need it the most. I'm also a proponent of this particular land use because this unique vertical integration approach with small scale agriculture as a backbone of it is really crucial for our state right now, and is proving out that the small scale local agriculture that's really key to creating more economic stability in our rural areas in Oregon that are struggling economically. So for us, we see this as an opportunity all the way around of being able to expand small scale agriculture, local agriculture into these rural communities and these local communities, as well as providing excellent services. The unique nature of this particular land use and being able to actually have a natural environment component to a service center, as other speakers have already noted, is super important. There is numerous amounts of research available that show that the
Mr.
natural
Brubaker,
environment.
sorry to cut you off, but you're well over your time now.
Okay, thank you.
Okay, thanks.
And next up, we have Eric.
Hey there, can you hear me?
Yes.
Hi there, my name is Eric Blender. I'm at 2925 Southeast Brooklyn Street in Portland, Oregon. I am a state licensed psilocybin facilitator, as well as a faculty member at the Synaptic Institute of Training here in Oregon. It's a training program for new facilitators, people seeking their facilitation license to work with psilocybin. And I've been working in this field for the past 15 years. When the ability came forward to become a legal licensed facilitator here in the state of Oregon, I embraced it. And one of the frustrations that I've had working with many, many different clients, military veterans, first responders, end of life patients, people working through some really serious anxiety, depression, and stress in their lives caused by our culture. One of the frustrations I've had is being really kind of forced to work in urban psilocybin service centers where there's a lot of noise from the exterior that does, even though the clients may not notice, it does impact their their journey. So having a natural facility in a nature-based space is so important, where it can be quiet and calm. 100% of my clients, 100% of my sessions in psilocybin service centers have been peaceful, calm, and quiet. People arrive being driven by somebody else typically. They're there for anywhere from 5 to 8 hours. They're in a calm and quiet session with me, and I'm there with them 100% of the time, making sure that everything is safe, making sure that they're getting a lot out of their journey. And then I am also responsible for their safety and making sure that when they are done with their journey, they've come back to Earth, they're totally safe and calm and sound and ready to re-enter society. Then they have a transportation plan, a safety plan, where somebody comes to pick them up at the site, and they never drive away on their own. They're driven from the site to either a temporary location or their home. And then there's follow-up, where we do a lot of integration with the clients. And, I just think that this is an absolutely appropriate and a pertinent use of farm, and a pertinent way to consume the farm products on site. Yeah, if a cidery can do it, and if a wine tasting can do it, where people drive in, drink alcohol, and drive away, then why can't somebody do it here with a safety plan and a pre-approved transportation plan, where they're going to be driven there and then driven away completely safe and sound? Thank you so much. I support this, LUCS.
Thank you.
And next we have Tim Moore.
Can you hear me?
Yes.
Hi, my name is Tim Moore. I'm at 688 West Jefferson in Sisters, Oregon. I'm the clinical director and co-founder of Broken Top Counseling, and I'm advocating for this service center in Bend. I realize my testimony isn't going to address the exact issues that Mr. Brooks is outlining, but I do want to just throw my support behind the idea that psilocybin in many levels has a stigma and a bias right now, and I understand that will eventually change. But what we're describing here is the future, in my opinion, of what is the best way that we can treat depression, anxiety, and PTSD, as well as substance abuse disorders, which is interesting to think that psilocybin could actually be effective with that. But the research does show over and over and over again just how effective these treatments are. If people need evidence, please go and do the research. It's there. The fact that this could be all of the services could be coming from one place is an amazing feat, including the fact that it would be in the current environment that's being described, which is close to nature. Just leveraging sort of the inherent therapeutic benefits of natural settings to enhance the healing is what psilocybin therapy really needs. I'd say, I also want to emphasize just how quiet and how peaceful most of these sessions are. I would say, in my experience as a certified psilocybin facilitator with the Integrative Psychiatry Institute, that I've very, very, very few times have I ever seen someone have a situation that was loud, and it's extremely contained. I can't really speak to the farm, but I have been around other mushroom farms, and there's zero impact on the surrounding environment. I do think we also have an opportunity to do what's right for the people who have experienced trauma in their lives, especially, I hear now that there are a lot of veterans seeking this out. I've participated in that as well. I think that having a place in this setting would be beneficial both to not only the economic and the community, but also education and getting people educated on the ideas of why this works and why it's so effective. So I'm here just to support this testimony.
Thank you.
And I believe that concludes our testimony in support. So I'll move back to in-person participants, and the first person we have up in opposition is John Bosch.
Hello. My name is John Bosch. I live at 63255 Deschutes Market Road. I abut this property on 170 feet on the west side of my house. We are here to determine if manufacturing, sales, and distribution of psilocybin should be allowed on this parcel. We need to reference a Luke's form that says this is a manufacturing facility. None of these uses are allowed on an SR 2.5 zone. These are not outright conditional uses or special uses. This process of producing a crop of mushrooms in Central Oregon is manufacturing. Look up the definition of manufacturing. You take a manufactured cargo container, you place manufactured compost into the container, you provide equipment to monitor, regulate the temperature and humidity of this container, you hook this container up to water and power, and you have mushrooms. Without any one of those 5 ingredients that are industrial supplied, you don't have mushrooms. An environment has been manufactured to produce this crop. Without the manufacturing equipment, they will not be able to provide this commercial crop. This is manufacturing. This ground is better used as farm ground. You don't need it to produce mushrooms. The entrance to this facility will be on Yeoman Road. It'll be 24-foot wide commercial use entrance. It will be 24-foot wide road for 370 feet from Yeoman Road to this commercial facility. It goes right in front of Mr. Christensen's property for that distance. On this site, which is an 1.5 acre portion of the 1.32 acre lot, the following is proposed. 1/3 of this 1.5 acre area will be a reflecting trail. This reflecting trail is said to be ADA graded, but it's not ADA compliant. The rest of this 1 1/6 acre will be covered with concrete parking, concrete walks, unspecified walks, asphalt, septic tank, drain field, the second on this parcel, surface drainage swales, 3 manufacturing buildings made out of containers, manufacturing fenced yard, service center, yurt, trash enclosure, bike enclosure, and landscaping. All of those amenities are 40% of this property. And that's just the 1 acre, 1 1/6 acre. What this causes for the people who live around here, lights. They're going to be lights. You say you're going to work from 10 to 6. It gets dark at 4. We're going to have lights in our bedroom, in our living room, in our family rooms. The noise from traffic, I don't care. You may say cars don't make a heck of a lot of noise, but you start closing doors, talking to your friends in the parking lot. I live 200 feet from the property line and 20 feet above it. This all reflects back up to me. I can hear anybody in the whole neighborhood.
Mr. Bosch, sorry to cut you off, but you are well over your time.
This manufacturing process is packaging. It should be in an IL zone. This dosing facility, it should be in a serene environment. Having it in the middle of an IL facility, in the middle of a neighborhood, across the street from a soccer and pickleball field, is not low key. This will ruin my property values. It doesn't fit. The bottom line here is we're trying to provide people with mental health through the use of drugs for those who want it. This is voluntary. Thank you.
Next up is Alan Coyle.
Thank you for the time. My name is Alan Coyle. I live at 21210 Yeoman Road. I live next door to the location identified in the application in question. I will not argue the testimony that we need a facility like this. It just needs to be done in the right place. I would like to start by thanking Deschutes County for their diligence in creating the zoning codes and land use requirements for Deschutes County. They allow for the growth while maintaining appropriate use in our communities. It is these codes and OHA 333, which defines the psilocybin use, that I will use to demonstrate that the application for psilocybin manufacturing and psilocybin service center at 21230 Yeoman Road must be denied. This property is zoned as SR 2.5. Therefore, the land use codes related to DCC 19.20 and related codes must be applied. I will first focus on the codes for the underlying zoning district. DCC 19.04.040, which provides definitions for this district, states that accessory structures or uses means a structure or use incidental, appropriate, and subordinate to the main structure or use on the same lot. Furthermore, this code defines principal use as the primary or predominant use to which the property is or may be devoted, and to which all other uses on the premise are accessory. Deschutes County Code also states that an accessory use shall comply with all requirements for a principal use. Let's assume that agriculture is the principal use on the property and that it will be psilocybin manufacturing. The application states that psilocybin manufacturing on the agricultural land in this zone is allowed as the application was submitted 1 day prior to the rule being changed. Based on the assumption that psilocybin manufacturing is the primary use, the existing residence must be accessory use according to the definition of primary use. However, OHA 333 states that a residence may not be accessory to any psilocybin license uses. This means that for this property, the existing residence must be the primary use, not the psilocybin use, since the residence already exists. Agriculture can still be allowed, but it is the residence is the primary use. OHA prohibits all psilocybin license activities as accessory to residences. Therefore, neither manufacturing nor a service center can be permitted on this property according to OHA 333 and Deschutes County and other Deschutes County codes. If the land was vacant, maybe this could be allowed, but the land is not vacant. Based on these codes, the application for the service center and the manufacturing must be denied. Finally, I would like to address the residence on the parcel. The residence is not included in the application, and psilocybin licenses cannot include or overlap with a residence. This is outlined as I stated in OHA chapter 333. Therefore, this residence may not be used in any activities related to psilocybin licenses. I'm aware that this residence has been used in the past for facilitated psilocybin sessions. I ask that any such use in the future results in the loss of all psilocybin licenses for those involved, whether this application is approved or not. Thank you.
Thank you.
Next up is Rebecca Seago-Coyle.
Thank you. My name is Rebecca Seago-Coyle. I live at 21210 Yeoman Road, next door to the applicant. So I'm not opposed to these services. However, I am opposed to the location. I appreciate everyone who shared their testimony tonight, but I would like to point out that none of those folks actually live in our neighborhood. I would ask you, if you want this, would you want it next door to you? And while it is easy to focus on the emotional impacts that these facilities would have on our neighborhood, I want to focus on the zoning codes and the Oregon Health Authority regulations to ensure that the use of the property is both compatible and suitable for our neighborhood. So to start with deciding whether it is compatible or suitable, the applicant has indicated that there will be little to no impact on the surrounding neighbors. That's a statement that cannot be proven at this time. There are too many unknowns and assumptions. And while the applicant has been planning this for over a year, many of the neighbors were only informed about this 3 weeks ago. Again, deciding compatibility and suitability. Is the application actually complete? While it may meet the minimum county standards to submit the request, we don't understand the long-term impacts of this type of business on the land and the neighboring properties. As was stated before, the applicant submitted their proposal one day before the change of zoning rules, which allows them to be grandfathered in, yet there's no business plan associated with this application. I do appreciate what they have shared tonight, but it's still not enough information to make this decision. So since Oregon has decided to make manufacturing and service centers legal, we should do our due diligence to place them in the areas that are accessible and conducive to our environment and support our communities. Here are just a few questions that I have after reading the proposal that the neighbors deserve the right to understand before a decision can be made. First of all, neither the property owner or the applicant actually live on the property. I doubt they even know their neighbors. We never heard of Piper until we got a card in the mail. So who is actually going to own the business? The landowner is a resident of California, and while the applicant is an Oregon resident, she doesn't live nearby. So rules state at least 50% ownership needs to be an Oregon residence. There are some other environmental aspects that I'll skip over for time at the moment, but one of the things is at the end of the day, this property is less than 5 acres. So how much is the applicant actually anticipating on producing? How much traffic is expected? I love how they think that this is a serene area. It is serene, except it is on a major road. There is noise. And there's plans for 18 parking places. That alone will impact the neighbors surrounding them, 16 parking places. The other thing I'd like to bring up is security. How will that actually be handled? We've learned from marijuana farms that there was an uptick in crime in the neighborhoods. So how will the neighbors be supported? So there are many other questions I have to understand how this business will run and impact our neighbors, but I'll stop there. My point is, how can we determine compatibility and suitability without all the information? As my husband stated, the applicant actually did say that the main use would be manufacturing. However, they failed to mention the 4,200 square foot residence on the property, which is currently the main use and utilized as an Airbnb. And again, according to OHA Chapter 333, states the licensed premise cannot include a residence. I know I'm out of time, so I'll just skip through this. But, at the end of the day, I also don't believe that this application was submitted with the same spirit of compatibility and suitability that the county or the community requests. I ask that, those who are making the decision, please look at the actual land use, the intent, not only short term. Don't just make this decision and think, oh, we'll figure it out later. This does have a really big direct impact on all of us. So I'll leave it there. Thank you.
Thank you.
Claudia Christopher.
Hello, my name is Claudia Christopher. My address is 21220 Yeoman Road. I live right next door to the said property. I'm opposed to having the Psilocybin Service Center next to my home. I understand location plays a key role for the client to obtain their best experience with this drug. Yeoman Road is very populated. In 2022, the Deschutes County Traffic Count Summary counted 1,852 vehicles per day. Petrosa recently completed their subdivision of 260 new apartment units at the end of Yeoman Road. The traffic count on Yeoman Road has increased substantially since that completion. Air traffic coming and going to Bend Airport daily also adds to the noise level. Pine Nursery Park has 159 acres. 14 of those acres are dedicated to an off-leash dog park. That is directly across the road from the proposed site. Hundreds of people bring their happy barking dogs to this park. The other 145 acres are home to multiple sports fields. With that being said, this park is extremely active. Hundreds of children and adults enjoy this park daily. Tournaments are held in this park throughout the year. During these events, traffic and noise is elevated. People are cheering, horns are blowing, megaphones are used, sirens ring out at halftime and end of games. Yeoman is a wonderful, active place to live, but quiet and tranquil it is not. My family has lived safely on Yeoman Road for 25 years. Our boys were raised here, and now we are helping to raise our young grandchildren here. Living right next door to this proposed location is a great concern for us. Our grandchildren spend countless hours playing outside only a few feet from this property. We are concerned for the safety of our grandchildren when clients are under the influence of this mind-altering drug that causes hallucinations. In December of 2016, the National Library of Medicine published a study showing that 10.7% of users reported that while under psilocybin, they placed themselves or others at risk of physical damage. 2.6% reported being violent, physically aggressive with themselves and others. No one should be exposed to this type of threat, especially my grandchildren when they are out riding their dirt bikes and playing. Could this noise trigger the client's trip to go badly and put my grandchildren at risk? Based on the 16 proposed parking spaces, we assume there will be multiple individuals microdosing at the same time. This could easily become a safety concern for both our community as well as Bend Parks and Rec visitors. The smell of growing and cultivating mushrooms with compost could be unbearable for our community, which would only reduce the value of our properties. So I ask you, please take great consideration in not allowing this facility in our neighborhood. Thank you.
Thank you.
Paul Long.
Hello, my name is Paul Long. I live at 63148 Desert Sage Street. I'm in an adjacent neighborhood. First, I'd like to thank the first responders and our military veteran for their service. My point may be relatively moot on kind of the definition of a crop. I know this has already been passed. However, what I find interesting is that the psilocybin is a controlled substance, which is recognized as a Schedule I illicit substance by the federal government. I realize that's different in Oregon. However, it is under Oregon Health Authority and not under Oregon Department of Agriculture, which is where marijuana falls under an agricultural industrial crop. I think the functional mushroom issue may be different than the psychogenic version. Another point that I thought was interesting that got brought up by our mycologist was testing for pathogens. And if I lived right next to the facility and there's even some concern of leaking pathogen into the soil where my farm may be or my grandkids could be playing, that would not be at all anything I would be interested in. Furthermore, Oxford Dictionary defines a crop as a cultivated plant that is grown for food, especially a grain, fruit, or vegetable. I do not think that psilocybin has any nutritional value. People do not cook with it or use it other than for medical purposes where they're being treated and micro-dosed. They have to be administered by somebody, so it's given to them. These are all signs that this is a medicine and not a crop that can be just grown on a local in the city property. Thank you for your time.
Thank you.
Steve Christensen.
Hi, my name is Steve Christensen. I live right adjacent to the property, 21240 Yeoman Road. And I just want to state, I never received a notice of this land use application. I've heard about it from my neighbors about 6 days ago. I'm not going to contend the proposed benefits of psilocybin or anything like that. My concern is just that this is not the most appropriate location. Much of what I want to say has already been discussed. This really is a beautiful property, but it's not that serene. We moved there 6 months ago from Powell Butte, And I remark to my wife and my kids every day how noisy it is. You can hear the trains 2 miles away. You hear the soccer games every day. You hear the pickleball games going on all day long. We're in the direct flight path of life flight helicopters coming and going from St. Charles. It's busy. And I'm kind of questioning about the serenity of the location. I hear from the owner of the property that it's going to be inside and there's going to be some house plants, but then I hear from other people there's going to be walking paths. What is it going to be? How are these people going to be treated? How many are going to be treated on a daily basis? There's just so many unknowns, and a neighborhood is not where these things should be figured out. I'm raising my 5 children there. They deserve to be able to go out into the yard and safely play without wondering what's happening, because there are unknowns. Is there a safety level? Sure there is, but there's so many unknowns involved that we just don't know if this is a compatible use for this land use. Thank you.
Thank you.
Stephanie Christensen. Okay. And then I also have a Lucy, Lily, Cooper, and Calvin. Okay. Okay. I believe that concludes our in-person opposition testimony. If anyone's online and wants to provide opposition testimony, please raise your hand. Jim Newton. Jim, can you unmute, please?
Hi, my name is Jim Newton. I live at 21145 Scottsdale Drive, Bend, Oregon. We live about a mile north of the area in question. And by profession, I'm an Oregon licensed professional engineer, professional geologist, and certified water right examiner. So I present and have been in front of Deschutes County many times. So one of the things that I guess is really concerning to me, just from a, using the backbone of what I do for a living, is, the zoning was mischaracterized by the applicant's attorney in that under SR 2.5, it has a requirement that agriculture is an outright use. However, under code 19.92.020A, it explicitly states that a grain house or hothouse may be maintained as an accessory to a dwelling provided there are no sales. So one of the concerns with that is the misrepresentation that it's an exempt use for agriculture. The growing of mushrooms is agriculture. That would be an allowed use and an outright use in an SR 2.5. The production, process, sale, and treatment falls under sale and or a medical facility service, which is not zoned as an outright use in SR 2.5. Further, applicant's counsel represented Pine Nursery Park, which is across the street, literally, 40-foot county road, is a sports complex. However, it's not simply a sports complex. It is a Bend Park and Recreation District community park of 159 acres. Again, that falls into community service as opposed to a sports complex, which would indicate that it's operated as a business. It's not. It's operated as a community park, which falls into different criteria. Further, one of the reasons why the fact that this includes sale and or treatment under 1992.020A, which is not allowable or outright use in a SR 2.5. The other issue with that is, excuse me, sorry, I was trying to take notes here. One of the other pieces with that is the county should allow this to go to site plan review. And as criteria for site plan review, you have to come up with all of the on-site uses, conflicting uses, and the applicant noted that they would compost on site. Compost of product like this would require a WPCF permit, water pollution control facility permit, which would fall under DEQ and would require a separate Lux in addition. So, again, I get that the applicant is trying to ride the day before legislation went into effect. This is not an exempt use on the site because it includes sale and treatment.
Thank you, Mr. Newton.
And I don't see anyone else online with their hand raised.
All right. It does not sound like we had anyone sign up that was neutral.
We did not, and I don't see anyone raising their hand in the room.
Okay, we can get back to the applicant then for rebuttal.
I want to say thank you, everyone, for coming. I'm sorry I didn't give you more notice. You didn't really know how this was going to go. And am I sure this is?
So could you please speak into the microphone? I can't hear.
Yep. Okay, I'm sorry. I was addressing the opposition.
Okay, please address the data so we can get your testimony and get your rebuttal on record, please.
Yep. Okay. Piper Lucas. And I also want to say I live at 65729 Old Ben Redmond Highway. I live in the county and I know my neighbors, and it's important to be in good standing with neighbors. That's why I sent a handwritten note to everybody. I just want to, there was a comment written about, a steak restaurant next to a cow and cattle. And that was a really good point. I think the comment said that if you raise cattle, does that then mean you get to have a steak restaurant? And in this case, the state law makes it so that you cannot have a steak restaurant unless you go through this process. It is appurtenant. The way that the law is written is that growing mushrooms is appurtenant to where you take the mushrooms. So it's extremely difficult to not have them connected. There was a question, let's see, the safety, I hear that, the safety of grandchildren. That is important. It's also law that if people go outside, they are with a facilitator. They will mostly be inside. So I just want to address that I heard that, and I also share that concern. There will also be fencing, privacy fencing, where the trails will be on the very back corner. And I definitely will and am open to adding more fencing if that is a continued concern for people. There was also a question of what is this business and who are the owners? So I am a co-owner, and my partner Jarek is also a co-owner that is also here. So I just wanted to put a face to that question. Yeah, okay, farm use, I think we got that. And I'm going to leave it up to Alex to speak now.
Thanks, Piper. Thanks, Hearings Officer Brooks. So just a couple of responses here. First, I would just like to say, in terms of all of the comments that dealt with the design elements and crime concerns and serenity, etc., those are not applicable here because they are not within the criteria for what constitutes an outright permitted use, which is simply the agricultural use for the manufacturing facility and functional mushroom grow facility, and then the accessory designation for the psilocybin service center. In terms of the fact that the license type is called a psilocybin product manufacturer, does not make it manufacturing in terms of an industrial use. In fact, if you look at the land use compatibility statement, the only endorsement requested is fungi cultivation. And as I mentioned earlier in my presentation, Oregon law defines psilocybin producing fungi as a crop, which falls under the agriculture definition in the DCC. In terms of the folks who brought up the fact that a residence may not be licensed as a service center, that is true under the applicable regulations, but the definition of a residence there is real property inhabited by an owner, renter, or tenant, including but not limited to manufactured homes and vehicles used as domiciles and attached garages or other structures that may be directly accessed from any ingress or egress of a residence. And the proposal here is not to use a garage or any other building that is attached to a residence to house the service center. So that's not applicable. And then in terms of, what constitutes the primary use of the property, that is not particularly relevant here because the DCC governing the outright permitted uses does not require that the accessory use be accessory to a primary use. Primary use is not a defined term in DCC Title 19, and the language of the list of outright permitted uses states accessory uses customarily appurtenant to a permitted use, meaning any permitted use, not a primary or principal use. Again, terms that are not used in the DCC 1920-020, which defines the outright permitted uses. So whether there is a principal or what some would consider a primary use, that is not required in terms of an accessory outright permitted use. It merely needs to be accessory uses that are customarily appurtenant to a permitted use. And here, the agriculture, edible, and psilocybin farm would be the permitted agriculture use, and the service center, as we discussed at length, would be accessory use customarily appurtenant to that agriculture permitted use. Regarding the comment that invoked DCC 19-92020, accessory uses and structures, the applicant is not proposing a greenhouse or a hothouse on the premises. So it's immaterial whether or not a greenhouse or a hothouse accessory to a dwelling, which again, we are not proposing an accessory use to any dwelling. The only provision that would apply is C, an accessory building should not be located within 10 feet of any principal dwelling existing or under construction on the same lot, and that is not what we are proposing. None of the manufacturer or service center would be within 10 feet of the principal dwelling. With that, I would like to request to extend the open record period on a basis of 773 days. And that concludes the applicant's rebuttal.
Okay. One follow-up question for you, since you're addressing the existing residence that's on the property. Can you give me a little more detail about what the role of that structure is with the rest of the psilocybin uses? I mean, will it continue to be a residence for someone? Or is it part of the psilocybin use?
It is not part of the psilocybin use.
Okay. And then have you, in your opening remarks, you provided some pretty good detail about the intensity of the psilocybin use, with the cultivation versus the service center. Is there anywhere in the record where you've sort of quantified the proportion of the overall use on the property that relates to the residents versus these psilocybin uses?
No, because our contention is that it's immaterial, since the accessory use is only to the agriculture use, and the agriculture use is not accessory to, neither are accessory to the dwelling use.
Okay. I think what I'm responding to was your argument at the very beginning, when you were describing basically the difference between the predominant use and the subordinate use. And so I guess if I'm supposed to figure out what the predominant use of the property is, and it has a residential use on it, if I'm able to make findings about the scale of the residential use compared to any other use on the property.
I was referring to the predominant use sort of in the universe of a permitted use and an accessory use to that permitted use under DCC 1920-020. So it's our contention that nowhere in the applicable code does it require accessory or relationship to a so-called overall predominant use.
Okay, thank you for that clarification.
Sure.
All right, and I don't have any other questions for the applicant. I hear your request to keep the record period open, so I'm going to turn over to staff to see if they have any final comments, and then depending on what they say, we'll decide if there needs to be any more discussion.
Thank you.
I don't have any closing comments. No, thank you.
Okay. Then I think it makes sense to leave the record open for the 7-7, and then we'll do the 3 period, since that's what the applicant has requested for the final legal argument. So Mr. Ripper, I think you probably have some instructions for how that will proceed, but before you get to your instructions, I'll just say my take on that is that what we're doing is we're leaving we're going to close the hearing tonight, but we're going to leave the written record open basically in 3 phases. The first phase is going to be for 7 days, where any participant can provide evidence to the record. There's going to be a second 7-day period I'm going to call the rebuttal period, where anyone can rebut the evidence that is provided during that open record period. And then during the last period, which is only 3 days, the applicant and the applicant only will get a final legal argument with no ability to introduce new evidence. So with that, if Mr. Ripper, if you have the instructions.
Sure. Bear with me. All right. Yeah, so again, as Hearings Officer Brooks explained, the first period will be for new evidence and testimony, and that period will close Tuesday, April 16th at 4 p.m. The rebuttal period will close Tuesday, April 23rd at 4 p.m. And then the final argument, which is again for the applicant only, will be the following Friday, April 26th at 4 p.m. And just some housekeeping stuff here before we close up. For these open record periods, please keep in mind everything should be addressed to me. So any email submittals, use my email. It's jacob.ripper@deschutes.org. Or you can drop them off at our offices at 117 Lafayette, which is just across the street. And just to let everyone know, the county cannot retrieve information from a website link or personal cloud storage devices. And it's your responsibility to submit all evidence and testimony you want the hearings officer to consider. And this is a really important point that I want to stress. All electronic submittals must be received by the county server by 4 p.m. that deadline. So don't wait until 3:59 to click send, because sometimes there's a delay between sending an email and when it hits our server. Yeah, so with that, that's all that I had.
All right, thank you. So we are now going to close the hearing. The record, the written record is being left open as just described by Mr. Ripper, and we will go off the record tonight. It is 7:58. Thank you, everyone.